Count 5, child abuse, 4th degree, alleges that on or about August 5th at 5:17. Are you falling asleep, sir?
Not falling asleep, just confused. I don't understand how half these charges or any of these charges, I'm going to need a lawyer for sure, because it's how did I prevent anyone from doing anything when she willfully called the cops on me? So I just don't understand any of that. She willfully left the apartment. She willfully did anything. How did I prevent anything if she just did those things? She did those things, you know what I mean? Let alone child abuse. We have a child together. How did I abuse the child?
See, I'm not trying. Exactly. I'm sorry, Mr. Audio, are you representing him today?
Yes, Your Honor. I was able to get an intake done earlier today.
Oh, I'm not used to attorneys allowing their clients just to freely talk, so I'm not going to stop.
You asked me a question, I'm not falling asleep. That's what's going on.
Were you falling asleep? I didn't ask you to say anything about the facts of the case.
I'm not falling asleep. I'm just confused on how I'm being charged with things I didn't do.
Okay.
Yes, that's ridiculous. If I get life, that's unbelievable.
I didn't ask for you how you felt about it. I asked if you understand the maximum penalty. Okay?
Yeah, I understand you.
I also have file number 25-01864. Let's see here. It looks like that's a domestic violence file that you have pending before Judge Buchanan with the same victim, which means, and I see here that there was a no contact order in place, that you have a final pretrial on August 11th and a jury trial on September 8th. So there's a bond violation pending on that file because you were not to be in contact directly or indirectly with an Austin IOR during the pendency of the domestic violence case. You also were not to commit any crimes or pick up any new charges. So that matter will be set for a hearing for Judge Buchanan on the bond violation, and the court will enter a not guilty plea on your behalf. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand and mute. Or repeat, anything that you say on this record can be used against you. And so you have the right in this file, the new felony file, to proceed to a preliminary examination. You have the right to have that preliminary examination within 21 days of today's date, unless the court finds a good cause to go beyond that 21 days, or you waive the 21 days. You're currently scheduled for probable cause conference before Judge Stacia Buchanan on August 15th at 9 o'clock in the morning. You have a preliminary examination before Judge Buchanan in person at the court August 22nd, also at 10 a.m. Did you get a notice to appear?
No.
You did not get a notice to appear?
Oh, they just gave it. I guess I haven't had a chance to look at it. They gave it to me 2 seconds before I was called up here.
Okay, and where did you put it? In your pocket?
It's in my hand.
Can you see and make sure you have the correct dates on there?
Friday the 15th, Friday the 22nd.
Very good. Okay, you have the right at the time of your preliminary examination to require the prosecutor establish sufficient probable cause that a felony was committed and probable cause sufficient to charge you with the felony. You have the right to take this matter to trial and the right to maintain your innocence until proven guilty. You have the right to require the prosecutor to prove each element of each of the charges to be brought against you beyond a reasonable doubt. You have the right to maintain your silence at trial, and that can't be used to prove or imply that you're guilty. You have the right to question or cross-examine in court any of the witnesses called to testify against you, the right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you. Do you have any questions about those rights?
Yeah, I do not want to waive my right to a speedy trial. I do not want to waive my right to a speedy trial.
We didn't say that you waived your right to speedy trial. We know that you will not waive your right to that, sir.
I do not want to waive my right to speedy trial under any circumstance.
That was not my question. That was not my question. My question is, did you have any questions about any of the rights that I just went over?
No, ma'am.
Okay. What is your address? Is that the address of the protected party?
Yeah, I have another address as well that I can stay at besides there.
Well, obviously, because you already have a domestic violence, so you can't stay with her, and you know that.
I know
Where you
she stays
stay?
in my place.
Are you on probation or on parole?
Oh. I would just like to say being held against her will, though. I went to the hospital.
Sir. Please stop.
That was the day before. And then the day that I got arrested the next day, she just left. Like, at no point did I have her phone, stop her from doing anything. Like, to say that I held her against her will is just ridiculous. Or took her telecommunication device is just ridiculous.
Please stop talking.
Okay. I'm just saying there's plenty of evidence that would prove I didn't do that. She left the house multiple times before she came to the decision that she was going to call the police because I didn't want to reconcile with her.
Counsel, you can address fine.
Thank you, Your Honor. So, Mr. Davis, we do acknowledge the seriousness of the charges. What I would say is that he is someone that has lived in Michigan his entire life. He does have another separate place to stay to keep him away from the alleged victim with the address that he just gave. I would say that according to what he stated to me, is that he does not have a history of failing to appear either. So I don't think there's any danger of him attempting to flee this court's jurisdiction. I do think that these are with these allegations that any concern for the public could be alleviated through the use of a GPS tether. So I'd be requesting a low 10% bond, Your Honor.
The prosecutor here to be heard on bond.
Yes, Your Honor. First, it appears that he's been misleading his attorney. He's absolutely been charged with failing to appear in prior domestic violence felony cases.
I told my attorney that.
Secondly, he has not
misleading my attorney.
Sir?
I did not mislead my attorney. My attorney forgot what I had said.
Davis,
My attorney
Mr.
forgot what I had
Davis.
said.
Mr. Davis, you have
What?
one more outburst and you are remanded, and we want to address your bond. Close
Okay,
your
but there's
mouth. Close your
inconsistency all through here.
mouth. Remand. Bond denied.
Thank you, Your Honor.